1, 2, 1, 2, 3. Okay, so I have a whole slide pack here dealing with implied terms, and we can go anywhere in here that you want to, but I want to talk about terms that are in good faith, the good faith argument. And I think in doing that, we will touch upon the other elements. So let's have a look at terms that are implied by good faith. Okay, interrupt me, talk to me, ask questions as we go. So why is this even an issue? Clearly, more than half of the chapter in your textbook goes to this question, so it is kind of the interesting part of the question, there is that. And I think the rest of it, understanding what an implied term is, whether it's a fact, law, or custom, understanding that if you only need to find one, it might be, a term might be implied by more than one, but as long as you can find one, that we've got quite methodical tests there, and you sit there and understand that in the context of courts don't want to be commercial. They don't want to step in and write terms for the parties if they don't need to. But then we end up in this interesting position where if we just go back and think all the way back to all of that turgid reading that you had to do for the first week and asking yourself, why do we have contract law at all and what is contract law for, you'll remember that there are a number of arguments around this private law idea, that commercial people should be able to reach arrangements and understand how they work consistently, and that it's good for economies, it's good for countries if contracts are treated in the same way consistently. But a consequence of that is that we end up with this kind of fiction of equal bargaining power, where we have two parties with equal strength who've negotiated an arrangement, and the court shouldn't care whether it's a good deal or a bad deal. It should only care that it is an enforceable deal. And if it's an enforceable deal, then it's going to look at whether all of the elements are in place, and if they are there, then it's going to construct or understand the contract using some pretty standard principles. That all works in theory, but in practice we know that that actually rarely happens. Most of the contracts that the people in this room and the people who are listening online are going to enter into in their lives, they will not negotiate. By far, they will just be presented. They will be presented as invitations to treat. You are effectively manipulated into making the offer so that the other party can decide whether or not to treat with you. So think about the biggest deals you will do in your life. For many of you, that will be borrowing money to buy a house, or buying a house itself, or entering into a contract, say, with a university to provide you with a Class A education. Often these are done, you are required to treat on the basis of the terms that presented at the invitation to treat stage. You then apply for the loan, you make an offer for the house, you apply to go to university, and then if you are accepted, the power is in the party who accepts, then you do so on the terms that they presented in the first place, effectively. So the question then becomes well, wouldn't the world just work so much better if parties who are presenting terms were required to do so in good faith, or required to use good faith in the way they exercise their power? So an implied term of good faith would oblige parties to refrain from being uncooperative or acting unfairly in both the performance and the enforcement of contractual rights and responsibilities. Think about how many contracts we've seen along the way where if there was a contract, a party had a right to do something that was effectively a unilateral right. such terms, the additional terms as my solicitor sees fit. If X happens, then we can terminate the contract. And the other side of this is a duty of good faith could supplement an express contractual power vested in one party to terminate a contract because of some default that the other party has made, unless there was some good faith obligation, that they could only use that right if it's fair. But even so, think back to what a contract law is even for. And this is why, you know, one level you think, yeah, it should be fair. But then being fair requires that judges decide what fair is. And what fair is changes over time. It responds to community norms, to community pressures. And whilst it is a hell of a lot better than it was when I was a girl, I'm not sure that the commercial bench represents a great cross-section of the community at this stage. And is that really what we want our courts to be doing, to decide what's fair or not, or following the rules to work out what a contract is? I'm trying to do this without judgment, and to be quite frank, I don't think I have a view. Like, typical lawyer, like you get to the stage where it's like, I'll work with whatever the law says that the rules are, okay? I will work with that. And I can see lots of problems for the way that I write contracts if we have this universal duty of good faith. You then ask the question, well, if you've got an implied duty of good faith, and it's implied as a matter of law or fact, then the rules say I can negate a duty of good faith. So it's one thing not to put in a contract, I will act in good faith, or that I'll only exercise this clause in good faith. It's one thing to leave that out. It's another thing to put in a clause that says nothing in this contract requires me to act in good faith. Can you see? Because at the end of the day, contracts are written during a negotiation. And if you guys are negotiating an agreement, at that point in the day, you're usually quite excited. You're expecting it all to be awesome and to go really well, but nothing will put the dampener on your negotiation more than your lawyer saying, yeah, don't promise to act in good faith, or they're not promising to act in good faith. Think about how that works. So I can see lots of problems. I don't particularly have a view. I possibly should care more about contract law than I do. I certainly should just not say things like that in CES week. But look, at the end of the day, we learn, I've been doing this for 30 years. You get to the stage where you work with what you're given. But I think it is a really interesting exercise to think about what these changes will mean. And the reality is these changes are reflected. There is a duty of good faith in the US. There is an equivalent sort of in the UK. So the US code actually has it built in. So, and you will have seen with the cases that you're reading this week, a lot of the cases the judges will take themselves off and explore what happens in other jurisdictions. So it's not impossible that legislation will just come in and say, okay, this is what has to happen. And that has to an extent happened with the unfair contracts regime, which I've examined in one of the desk lectures as well, and we will talk about more next week. From memory? Oh yeah, well we only have next week with content and then we do revision, right? So we better talk about it next week. So think about some different scenarios. These both come from your textbook. There's one on the next slide as well. A vendor and a purchaser enter into a contract for the sale of land. Performance for the contract is subject to the government approving a plan of subdivision, which means that either of the parties can terminate the contract should the approval be given. After an unexpected rise in the value of land, the vendor decides that she doesn't want to proceed with the sale to the purchaser, but instead wants to sell the property at an increased value to someone else. So she doesn't apply for the approval of subdivision and seeks to terminate the contract. Is that good faith? Is that something that should be prevented by the law? A principal engages a contractor to excavate a construction site. The contract provides that the principal can terminate the contract following any specified breach of the contract by the contractor, subject to the contractor being given the opportunity to show cause to the satisfaction of the principal why the contract shouldn't be terminated. Contractor breaches the contract but presents a reasonably good excuse to the principal, but instead the principal goes to the pub, overhears some points of view that lead him to the view that the contractor is unreliable. Principal terminates the contract on the ground that the contractor has not shown cause to the principal's satisfaction, whatever that means. Is that good faith? Is that something that should be covered by good faith? Is that something that if you were the contractor, actually that's exactly what you planned all along, is you want to have that ultimate power of veto? Are we making a judgment call here? Should we be making a judgment call here? So one of the things that comes up in the cases over and over again is that the Australian law already provides a number of doctrines that have the effect of promoting fair duty. For example, the way that the rules of construction, when I'm talking construction here, I'm not talking about construction contractors, I'm talking about the way that contracts are read, work ultimately to find reasonable and objective ways of understanding what the parties meant. And apparently broad contractual right might be qualified by reference to other terms or surrounding circumstances. Also, specific terms can be implied by law or fact to regulate the conduct of the parties. So we'll talk about Renard, and Hughes Aircraft System and Air Services Australia is another case in that bundle that was in the reading. I'll probably stick with Renard because it's a bit more recent. No, I think it might not be more recent. Probably in the most senior Victorian case on this is Esso and Southern Pacific Petroleum. It wasn't in the reading, but it's mentioned a couple of times in both the text and the casebook, actually, in the narrative. Chief Justice Warren made this comment. So this is a 2005 case from memory, so it's a little bit old now. Courts have more often than not decided these matters on other bases and thereby avoided the conceptual difficulty that can attend the concept of a duty of good faith. Apologies for the typo there, which you never know, hopefully I'll remember to fix. So again, courts, the judges are saying, and this is consistent with what the High Court is saying as well, is actually, this is a bit of a Pandora's box. If we open up this duty of good faith, it could have all sorts of different ramifications. And before we go and say, let's create a new law, maybe we should look at the law that we've got already. And I'm guessing that Chief Justice Warren probably did really well when she was at university, because this I'm going to give you for nothing. You will do lots of critical analysis essays while you're at university. And lots of you will be asked, directly or indirectly, should the law change? And lots of you will come back with a vehement, yes, it should change. The ones who do really well will think about that very, very hard and understand how complex it is and how nuanced it is to get a law to change. And so you will answer that by thinking about what's actually already there. Now again, we've got the luck at the moment of being in an election campaign, but there have been a number of issues that have come up in the press over the last 3 or 4 weeks where both major parties are saying we need to change the rule in relation to this. So one, and I'm going to get the details wrong, one completely irrelevant here, but I think it'll make a good example, is about the amount of time that young people spend in prison. There's something about young offenders and the amount of time that they get. No, it wasn't for that. It was bullying, online bullying. Young people who are online bullying, that both parties have said that they should extend the sentence term to 5 years. There's already a maximum sentence of 3 years and it's hardly ever been used. So again, what should we do? What is the maximum? It's very easy to say, yeah, let's get a new law, but think about what's already there and the complexities of actual enforcement or otherwise. Okay, I know it's not a great contract law example. I'm just trying to get you into the right way of thinking about this. Election time. Election time, it does my head in too. So again, just because New South Wales in particular have come up with all these great ideas about what the law might be, I think actually there is something occasionally for being a little bit prudent and thinking, what does this mean, particularly with a wholesale change? So we're talking about this as an emerging area. We've mentioned this in the quiz earlier. Yes, lower courts have favoured the principle and they've actually applied it. However, it is worth noting that there are only a very small number of examples where there's been both a duty implied and it's been breached. So a number of the cases have got to the point where they've said, yes, there will be a duty of good faith here, but haven't gone quite as far as to say that that duty has been breached. High Court has not determinatively ruled on it. Do you want to ask a question?
This is from a common case law perspective, is that right?
Common law perspective,
yeah,
that's right.
Statute where it
No.
says to act in good faith, or...
Yeah, so if a statute says you have to do something in good faith, that is providing that standard.
Yeah.
And it's actually, Will, you've raised a really good point here, because there's also there'll be people in this room and thinking, well, what does it matter? But there are plenty of obligations that we have under statute where there'll be provisions where you have to do something, and then there might be something where you have to do something to a higher standard in good faith or otherwise. So particularly around employment law, OH&S is a really good example where there are some things that need to be done as soon as practicable, which I don't even think is a real word. I think some statute person put it in there and officious OH&S people are like saying practicable. But hey, what do I know?
Just another little point from the jurisprudential side and from a company law side. If we've got directors' duties and the case law that's emerged from there regarding to act in good faith and for a proper purpose, and that's now been enshrined in statute, we have not moved from having directors accountable to their shareholders to now a company and its potential customers to act in good faith. Well,
okay, that's a really interesting question and quite a complex question.
Is, yeah.
So there's a couple... No, don't be sorry. I mean, that's why I get to teach at postgrad level and don't have to deal with undergraduates. This is why we're here, my friend.
It's just got me going like...
So we do need to be careful in relation to time, but Will is absolutely right. Companies. 5 seconds on company law. A company is, as you all know, it's a legal entity. It can sue and be sued in its own name. It is a singular number of you. People will say they, and I will point out it's singular. I never take away marks for that. Actually, it's just that's what I do. So you've got a company. A company is owned by its shareholders, but ruled by its directors. So directors govern. Often directors will also be managers. So you think there are lots of different stakeholders involved in a company. But there is a distinction between the shareholders and the directors. Now, effectively, when companies were formed, the idea was that gentlemen could take risks with other gentlemen's money. That's what it was for. So if Will forms a company and we all invest in it, if he is the only director and we are shareholders, basically Will can do pretty much anything he likes with our money. But if he runs out and the company is being sued, we've just lost our money. The creditors for the company can't go past us, past the company to the rest of us. If Will hasn't acted in good faith, and I'm not suggesting that he wouldn't, but if he hasn't, or if he has otherwise breached any of the provisions of the Corporations Act, then there is a very good chance that the terminology we use is the veil will be lifted and those creditors can go to him. There are certain things where it doesn't even matter whether he meant it or not. Basically, if he breaches OH&S laws and somebody dies, he might still go to prison. We as shareholders don't do that, but he as a director might. If he doesn't pay employees superannuation, he could end up in prison for that as well. There's a whole lot of little carve-outs. So there's a high set of duties. So what Will is then asking is, if he as a director has all of these high duties, but the law doesn't have a corresponding set of duties where the company has to have these high duties with its consumers. Is there a gap there? Am I putting words in your mouth? That's pretty much what it is.
Yeah.
And I would argue no, there isn't, for a couple of reasons. One is that the duties that attach to a director attach to the director as opposed to the company. And the reason for having them attached personally to the director is so that there is somebody who can go to jail, because you can't send a company to jail, right? And ultimately companies are ruled by their directors, who are the ones who are making those decisions. And if they do it fraudulently or with a complete lack of regard for good faith, then in theory at least we should see some consequence for that. Now, and there's been some pretty high-profile company directors in Australia who've gone to jail. Alan Bond was an example of that. Probably not as many as we would have liked. Those of you who, like me, like documentaries about the GFC, like Americans can tell you thousands of stories about people who didn't go to jail and probably should have. So we've got that. Secondly, there is a class of consumer arrangements and where you do have direct guarantees or obligations to the end consumer. So where there is, it might not be a good faith obligation, although in the unfair contracts regime it's pretty close, but where you can't contract out. So again, the combination of linking a director or the humans, and in big companies, those humans very rarely have operational responsibilities. So they're the ones who hire and fire the people with the operational responsibilities. So, and if operational people are being fraudulent and hiding things, then they have a level of protection, but not so much that they can just hide behind that. That they do need to take an active interest in what's happening in the business and work from there. So that was a bit long-winded and a little bit more about another subject, but in the real world, these things float together. So what kind of issues arise? I mentioned one of these before. I mean, the one that sort of sticks with me is, can you actually exclude an implied term and say the parties aren't bound to act in good faith? It just... Just to quote Dennis, the vibe of that just doesn't feel right to me. So a few issues arise. Is the term to be implied in fact or implied by law? So far the courts have seen both. But the way that we understand where it arises could be different. Is an obligation to act in good faith the same as or similar to an obligation to act reasonably? Do we have some kind of Likert scale here where, we have an obligation to act reasonably, we have an obligation to act diligently, and then in good faith, and then in the utmost good faith? And how do we tell the difference between those things? And should we be, if in creating these different categories, do we end up with something lesser? And I don't know the answer to these questions. I will mention you guys get asked critical analysis questions all the time, and this kind of thing could come up on an exam. Might not too. I'm not making any promises. And what exactly does the good faith term require in a circumstance of each case? How do you know what good faith is? We just spoke a little while ago about how a term can be implied by custom. In order for that to happen, the term needs to be ubiquitous, but at the same time, a party could be subject to it even though they had no knowledge of it. So could a party who has no knowledge of a term not only be obliged to keep that term but act in good faith? Contracts are mutual. Particularly, think how many contracts you're a party to right now that you have not read the terms of. And don't lie to me, because think about your phone contract. If somewhere in the middle of your phone contract, it probably has a term that says something along the lines of, if you get unlimited SMS, it's subject to reasonable use. So you're not supposed to set up some texting. I don't even know what unreasonable texting is. Like, what does that look like? But do you have to text in good faith? Like, what if, like, you broke up with somebody by text and then suddenly Telstra's suing you because that was not a good faith use of their platform? I don't know. What does it mean? Think about it. Okay, Renard. Look, I say Renard, and so then I wrote Renard. Sorry about that. It's actually Renard. Renard Construction is the Minister for Public Works. So this is an oldie but a goodie. There was a written contract back in 1985 which included terms that are on the screen here. Renard, sorry about the spelling, needed to construct a pumping station as part of a sewerage project. They had to have practical completion by the 17th of January 1986. If they were to default, then the Minister for Public Works in New South Wales could call upon them to show cause why they should not exercise any of the following powers. Typical ask about writing. So you see the double negative there. You have to come and show cause why I shouldn't do one of the following. Take over the whole of the work and expel you from the work site, or cancel the contract. And if the minister wasn't satisfied with the explanation for the default and the reasons why they shouldn't exercise the contractual powers, then the minister can exercise the powers. Okay? Everybody there? So that's my person shoveling shit. I've just found out that I have to make my slides more accessible, which means when I have a picture or something like that, I actually have to go in and type in what the picture is of. I think there'll be many fewer pictures in my slides going forward because that's not fun. So, okay, bit of convoluted facts. That's why I'm going to put them here because I didn't find them easy to read in the text. So, Renard started construction, requested a number of extensions of time to complete and were given those extensions. There was an assistant project manager who sounds like he was a bit of an officious so-and-so, and he was not satisfied with the delays and the workmanship of the employees. So he recommended to his superintendent that they exercise this provision, that they call upon Renard to show cause why the minister shouldn't take over or cancel the contract. Renard said, look, no, we're ready and willing to perform, and the reason that we hadn't done as well as we should have is that there were some materials that should have been supplied to us which you were obliged to supply to us under the contract and you didn't get them to us. So the assistant project manager still, even so, recommended the cancellation of the contract. So the superintendent prepared the memo to this effect for the senior officer in the ministry. And so, you know, we're talking about the public servants here, so everybody's talking to somebody else. The officer himself was not made aware of the reasons for the delay, and that Renard had since increased the work, and once they had this paperwork, they were able to do the things the delays had stopped. So the officer actually had fundamentally both misunderstood what the problem was, but had ultimately misled the minister or the superintendent into understanding what the problem was as well. So the officer accepted the recommendation, and Renard was told to leave the worksite because the minister was going to take over. So we've ended up in this kind of clearly unfair but complex web with lots of different people. One of the reasons I like this case is I can so see it happening at this university. Just, you know, any large organisation where you've got lots of people with different levels of authority, lots of reporting lines, it's just so easy for something to get lost in the mix. And, you know, like, I know I won't mention any names, but I've got a student in this class, not in this room, but who's listening online, I hope, who's had all sorts of problems with getting access to text because of a bureaucratic situation that they are in, and yet there are a whole set of rules that make it very difficult when you can't get access to the internet and other issues. So it's just, I can see how it happens. Doesn't make it fair, but I can absolutely see how it happens. So the issue in case this time is whether the minister was obliged to act fairly, reasonably or in good faith in exercising the power that they had under Clause 44 of the contract. So Clause 44 of the contract is the one where, unless they've seen evidence that they're satisfied with, they can either take over the contract or they can kick Renard out. Okay? So Justice Priestley effectively was asking whether a term, this term, could be implied in fact on an ad hoc basis. So he went back to BP Refinery and he said, well, all of the criteria, except possibly the business efficacy element, had been met. So all of the criteria for working out whether we can imply a term is here. So I don't have any problem on that case. He said minds might differ about whether implying such a term makes a contract effective or not. Was it effective? Question, with the complexity that happened with these scenarios, it was somewhat ineffective potentially without it. On the one hand, the minister's officer based his decision on misleading information which served neither the minister's interests or Renard's in giving effect to the contract. So the implied term would make the contract commercially effective. On the other hand, the minister ultimately got the construction works done by taking over the works under the clause. The contract was therefore effective without any implied term, obliging the minister to act reasonably in exercising that power. So what do we think about this sort of two-sided idea? It's like version 1, the contract's effective for Renard if we imply good faith, if we limit the exercise of this authority to only circumstance where there's good faith. But it's actually effective for the minister. They have actually got what they wanted by exercising the clause without the good faith element. When we think of good faith, we tend to think about a mutuality, don't we? And neither of those are really good faith for both parties. Although it does appear, and again I'm relying entirely on the facts of the case here, that the minister would have got the work done effectively once the paperwork and the information had been provided. Renard was able to move faster, that they would have got very close to that practical completion date. So then Priestley says, Clause 44 could, on a plain reading, be used even for a trivial default, which would make the contract unworkable. So ultimately he found that the clause must be subject to the implied requirement of reasonableness. He then asked, can a term be implied in law? Now he's already found that it can be implied. Why does he go and look for another way of doing it? Doesn't want to be overturned on appeal. So if he's going to find that there's a clause, he's going to find 2 or 3 different arguments for getting there. You could learn from Justice Priestley, who I also assumed did quite well at law school, because he's adding his arguments, he's building his argument here, or his analysis with, okay, can it be applied in fact? Yeah, it can, but he's got a couple of tweaks there, things he's a little uncertain about. Business efficacy could go either way. So let's look at, can it be implied as a matter of law as well? So he notes that the case law suggests a sharp distinction between implication of terms ad hoc and by law. The former relates to a particular contract, while the latter relates to contracts within a class. But he says, and he is correct here, look at me correcting an appellate judge, there may be a good deal of overlap between the two types. He's already found implication of fact. So in this case, there's an argument that a power to terminate the contract, such as the power that is in clause that should be 44, can be constrained by an implied term of reasonable because the particular contract is in a standard form and there's no reason why the term couldn't be implied in every other contract that uses that form. And the standard form is also an example of a wider and common class of contract, building contracts. In this case, the contract falls into that class of contract, building contracts. There is an implied term at law for the same reasons as there is one in fact. So we have a similar set of arguments in Commonwealth Bank of Australia and Barker. So that case related to Mr. Barker had been an employee of the Commonwealth Bank, I think since he left school. I think he started in the mail room or, started as a teller or something or other. Worked for the bank for a very long time. And the question really came down to whether there was so he was retrenched. He was unhappy about being retrenched, as people often are. But he was saying, well, he had agreed to keep the bank's secrets and to act in good faith as an employee of the bank, but that in fact should be implied to be a mutual duty, that there should be a mutual duty of trust and confidence, which is something like a duty of good faith. So here, the High Court basically said that the implied term was directed to the relationship between an employer and employee rather than the performance of the contract itself. So in doing that, they looked at the baggage handling case, Air Services. Sorry, this is me. You can't see this online, but I'm pushing a baggage trolley here, where the question became whether or not, in that case, whether or not employees who had been caught on video stealing things were owed a reasonable amount of time and notice and fairness in their dismissal, or whether they could be summarily dismissed. So Chief Justice French and Justices Bell and Keane noted that the implied term was directed to the relationship between the employer and the employee rather than the performance. It depends on a view of social conditions and desirable social policy that informs a transformative approach to the contract of employment in the law. So effectively, their honours were saying that an implied term is not an application of a duty to cooperate, it's not a restatement of the duty of fidelity, that it shouldn't be accepted by any part of the Australian law that this standard applies to employment contracts generally. So they didn't actually say it's impossible to have this duty of mutual duty of trust and confidence. They're just saying it's not implied as a matter of fact or law into this class of contracts that are employment contracts. And again, they look to the cases where they said, well, and Byrne, that's the case I was trying to get to, Byrne and Australian Airlines, where they refer to this idea of the officious bystander and say, well, if at the time the contract was being made, if you said, now, was the intention that both parties would have this duty, the answer is unlikely to be yes. The employer would have no likelihood of saying, oh, of course, yes, we owe this duty. They would just be looking to receive it. Billy, were you trying to ask me a question while I was rabbiting on there?
No, I was talking about that bystander where they would have to deem it so obvious. So obvious,
yeah. It's like, so, and I kind of like, I don't know, there's something about the imagery of an officious bystander that I like. So these are very wordy slides today. I think just finding out I had to put names on, make my slides more user-friendly, clearly made me make them much less user-friendly. Sorry about that. So an implied term of good faith has been seen as coexisting with the implied term of mutual trust and confidence to the point of them being identified as a single thing. Russell and the Roman Catholic Church. Say no more. While the implied term of mutual trust and confidence was unanimously rejected in Barker, the majority identified mutual trust and confidence as separate obligations and left open the question of whether or not there's an implied duty of good faith. So what we're seeing as these courts get to the High Court, they are not adopting this idea, but they are not rejecting it outright either. So what you're finding is the cases are a bit like the note that I brought up at the beginning where Chief Justice Warren said, let's look to what the law we've already got. They're either finding that there is already a sensible reading of the contract that gets the parties where they need to be, that there is already some sort of something similar that's implied in law or fact, or they're just saying we don't need to answer this part of the question in this particular case. So the minority, which is Justice Kiefel there, Similarly, left open the question of good faith, holding that the question whether a standard of good faith should be applied generally to contracts has not been resolved in Australia. It's therefore neither necessary nor appropriate to discuss good faith further, particularly having regard to the wider importance of the topic. So she sounds like I do when my kids were like 14, just saying, I have made a decision, we need not discuss this any further at all. So, what about good faith in the context of the exercise of the power? So we've looked at good faith for, is there actually a duty to act in good faith? But then, is there a duty, if you have a power, do you have to exercise that power in good faith? So, Burger King and Hungry Jack's, people know what a Burger King restaurant is. They had 8,000 stores worldwide or something like that. Hungry Jack's basically entered into a franchise agreement with them. They were going to look and feel and serve food in every way like a Burger King restaurant, only under the name Hungry Jack's in, I think, the UK and Australia initially. We're talking about Australia here. Hungry Jack's had a non-exclusive right to develop restaurants in Australia, and they had an obligation to develop a minimum of 4 each year in Western Australia, South Australia. I don't know what WLD even means, which can be conducted by individual franchisees. Each new franchisee needed to be approved by the Burger King, the head office, at their sole discretion. So the question here, so basically it was a bit of a fraught relationship. By 1993, Burger King decided that they were going to take a much more active role in what was happening in Australia, and ultimately by March 1995 they were effectively saying they were just not approving franchisees. So they're exercising their discretion outright. Fabian, sorry? Yeah, well, question, it could have been an illusory term, but it's actually, I started thinking about this when I was reading the case to prepare for today, and I can't remember where I landed on it. But you could actually argue that it's an illusory term to start off with. Instead, they've taken, well, actually, I don't know. In the nature of a franchise agreement, there's a lot of different obligations that they're supplying. So if there was an abject failure of consideration, you would have the problem. But effectively, if they have, if you've got a system that they have to follow, so franchisees have to follow a system. They have to have restaurants of a certain standard set out in a particular layout. They have to use particular logos. They can only serve certain food. They can only buy things from certain places. And there are a lot of obligations that the franchisor has, but that just ability to say yes or no, that by itself, there's still consideration there. So they may well have ran that early on, though, illusory, for sure. So by the time we get to 1985, their relationship is broken down quite a bit. So Burger King imposes a freeze on Hungry Jack's recruiting from third-party franchisees. They're just not going to approve anybody. And they withdrew some financial and operational approvals. So the effect of the decisions made it impossible for Hungry Jack's to develop new outlets, which it was required to do under the development agreement. Remember, they've got to develop a minimum of 4 restaurants each year. And Burger King then subsequently served a notice of termination of the development agreement on them. So they'd made it impossible for them to do it, and then effectively sought to terminate the agreement because they weren't doing it. It's like a plot out of Suits, really, isn't it? So Hungry Jack said that the following terms were implied into the development agreement: that Burger King would do all that was reasonably necessary to enable Hungry Jack's to enjoy the benefits of the development agreement, so an implied term of cooperation, and that Burger King must act reasonably in exercising its powers under the agreement, and that Burger King was obliged to act in good faith in the exercise of contractual powers. Burger King actually conceded that there would have been an implied term of cooperation, as there was clear authority on that point. Consequently, the court only needed to consider the other implied terms, so the duty to act reasonably and in good faith. So, full court of New South Wales Court of Appeal. They looked at Renard, they looked at Hughes Aircraft, and they looked at Gary Rogers, which Renard and Gary Rogers are in your casebook. The courts in various Australian jurisdictions have assumed that there may be implied as a legal instance of a commercial contract terms of both good faith and reasonableness. They said normally reasonableness will be implied as a matter of law as an incident of the contract, particularly in a standard form contract containing a general power of termination. They found that there wasn't a distinction of substance between an implied term that a party must act reasonably and must act in good faith. So they saw these things as meaning the same thing. A term is implied, this kind of term is implied, so that the other party's enjoyment of contractual rights will not be rendered nugatory, worthless, or seriously undermined. So going to the illusory promise point. But the implied term of good faith doesn't restrict a party acting to promote its own legitimate interests. And I think this is the key point here. I probably should have bolded it. Does not restrict a party's acting to promote its own legitimate interests. So legitimate interests are key here. But where the contract confers a subjective discretion on one party to end the other party's valuable contractual rights, even for the slightest breach, an implied term of good faith will prevent the party exercising that discretion for a purpose extraneous to the contract. Now, another way of saying this would be that where one party has a right that, if exercised, could have such a fundamental impact on the other party's rights, then that right will be applied it'll be read very strictly. So exercising that right for third-party reasons won't be allowed. You can only exercise it exactly as set out in the contract. And I think that's how we would have heard it in Victoria, but in New South Wales it's pushed through to this idea of good faith. We're almost there, promise. Speaking of Victoria, Esso Australia Resources and Southern Pacific Petroleum. It's a 2005 case. Chief Justice Warren, I took a quote from this case very early on when we were talking about what was all there. She described the concept of good faith as nebulous, describing it as incapable of a definitional precision. Furthermore, Justice Buchanan was reluctant to conclude that commercial contracts are a class of contracts carrying an implied term of good faith as a legal incident. And so it's falling apart, this idea in Victoria of there being this general right of good faith for commercial contracts. Again, going back to your point earlier, Will, it may well be that in a consumer contract, and now we have a statutory unfair contracts regime, that might be seen very differently. And again, I'm not sure I like this result particularly, but this is sort of more legally logical to me if I go back to our first principle about what's a contract law for. Doesn't make it right, but it makes it consistent. So that's all I really wanted to say about good faith. Questions, concerns, frustrations? Okay, we really are on the home straight now. Most people have got assignments in. We got one more week worth of content. And after a mess up with technology this Saturday, which affected a very small number of you, I hope, it was only a small number, not that I hope it affected you. I'm not actually going to be available to do a shoot this Sunday night. I'm very open to doing it another time. And yeah, my guess is Friday is probably going to be a good day to do that, or a lunchtime. I will send some notes around. I thought I'd have Wi-Fi where I'm going. I'm doing the Great Ocean Road Running Festival on the weekend, and I might be asleep by 6:30 if I run 23 kilometres, but mainly it's a Wi-Fi issue. So I will find another date and suggest some times for you. I'm thinking everybody's over it, actually. We've had very small turnouts recently, but still like to be there. What we will do is we'll have content next week. The following week is going to be really important, okay? Usually my biggest turnout of the semester is the last week when people come to do revision. But we will be doing revision. I will be running through the structure of the exam, and it is different this year from how it's ever been before. So it's going to be important that you know about it. So heads up. In week 12, I will be releasing the fact scenario that you will be needing to respond to in the exam. We've never done this before. It's a bit of an experiment. I can explain the reasons for why, but you will be getting a contract to look at and a set of facts that you will have from the beginning of week 12 through to your exam. The same facts will be used on the OUA exam, on the face-to-face exam, on the deferred exam, and on for both. So I've written 4 exams with 4 different lots of questions that relate to this one set of scenario, okay? So, yeah, I can explain the reason for you, but those of you who are not interested in pedagogy will not really care. But I think it's going to give, particularly those of you who are listening this far into a recording and who are still in the room now, it will actually be giving you what I think of as a tremendously fair advantage, because you will be able to go into that exam with a set of facts. You don't have to panic about reading and all the rest of it in there. That 10 minutes of time, you can mark it up, you can write it, whatever. You will be able to imagine what kind of legal issues come up. The chances of you getting all of them, well, are actually quite good. You will think of things I haven't, and you can inform me later so I can think of new exam questions for the following year, okay? So it's going to be different, but I really think if you can make it for the for week 12, it will be great. So that'll be great. Question, or are you just saying goodbye, Kath?
No, it's a question. Just in an announcement that you put out in the next couple of weeks, can you please specify time frame for sending you problem questions that you will respond to with feedback before the exam? Just so that I'm clear.
Sure. Okay, I can do that. I'll think about that. What I will probably do too is I'm actually going overseas just in what is your swap vac week. So we'll be needing to do a lot by email if I need to talk to you, but I will do a shoot if you want it on I think it's the 16th. I believe the idea is the exam's going to be on the Monday. I'll do one on that Sunday night if you want me to. But I'm also happy to set up times with you as we go. I'll be in Vietnam, does not suck to be me. I'll be in Halong Bay. I'll put the computer in the Zoom so you can see the beach and the island behind you. And mornings will be better for me because of the time difference, because I'm actually working. I will be doing some work, so I will be busy. But we'll fit around it. Okay, go, fly, little angels, fly.